I don't know if you're frozen or if I'm frozen.
Yo, I'm not sure about my Wi-Fi. I'm in kind of rural Tennessee. So y'all in the chat are gonna have to let us know if it's choppy. Welcome to Defense Diaries, where we're gonna give you just facts. I'm your host, Bob Mata, and there's my beautiful co-host, Allison. What's up, girl?
Hey, babe. Hey, y'all.
I was supposed to be starting my vacation today, and of course on the plane, this opinion dropped, which I knew it would. I knew it was going to drop today. So, so if you hear a bunch of screaming in the background, it's
just the boys. It will be boys being boys.
Yeah, and they're all pretty hammered at this point. So, and seeing that I don't drink, I'm the only sober one here.
It actually made it easy for you to make this little escape. That they were all hammered.
Yeah, except they're hanging out outside the window over here and acting a fool. So obviously, a few things went down today, babe. I know you were still probably in the midst of your real work. So Gull, of course, issued a few orders today. Again, my standing rule is that I'm not going to be, putting her orders up for the near future. She's in the corner in my world. I'm not willing to put up her order. So basically today, she did grant the continuance for the hearing on the 12th. She kicked that to March 18th, 9 a.m., still in Allen County. So she did grant a defense motion. I think it's her third. I think she granted the motion for the discovery deadline, and then she granted the motion for the cameras in the courtroom.
Oh, how'd that happen? That's the Indiana Supreme Court.
Stevie did it. That's
right. So did she do anything about the whole they destroyed the evidence thing?
No, she hasn't done anything with that yet. No, and then she of course denied a couple of other motions. She denied the motion. Of course, she did. I'm trying to remember what motion she denied. I gotta pull them
there's the downfall for you not wanting to put her motions up.
Right.
Well, hey everybody. See a bunch of, is it grizzlies? Is that what they are?
Yeah, grizzlies. A lot of grizzlies in the house.
We're not doing the facties. That's out. We're doing something better than that. I'm vetoing it.
Wow. I love the facties.
I don't even, what does it mean?
Oh, so she denied the transfer. Can't believe I forgot that. She, for the third time, denied the motion to transfer Rick Allen out of prison.
See, it's that right there, that right there that makes it undeniable that there's bias. It's like you've been shown by too many people too many times, and to just keep ignoring it, that right there takes if there was that little slither I was holding on to like yesterday or whatever day it was where I said maybe she's gonna be so outraged by the gross negligence of the prosecutors that
I mean, I didn't expect her to rule on that.
No, but I set a hearing, set a date.
Well, she's got to give she's got to set a date. She's got to set a briefing schedule, give the state time to respond.
No, but my point was,
Jennifer Ockrant doesn't think that you have a full-time day job. Yeah, Allison's a full-time lawyer. So I just, and believe me, this in the podcast is a full-time job. I promise you. It's more than a full-time job. I'm 70, 80 hours a week on this stuff. So yeah, and Allie is a full-time defense attorney. So that's the facts there. So, and then of course she did grant, I thought there was a third motion that came out today. If Sleuthy's in here, she'll throw it up there. Somebody did. I can't for the life of me remember what it was.
All right. So why don't you do what you do best there with that 21-page Supreme Court ruling?
Yeah, it's actually, and look, I want to preface it with I mean, no one could be surprised. I mean, we knew what their order was. This is just their opinion as to why they reached the conclusions that they did. As far as Baldwin and Rosie, I mean, I think it's in line, with their decision. I don't think when I get to it, I don't know how much of it you read. I don't find any of it to be shocking to the conscience.
I only read the first couple lines, so I'm gonna hear it for the first time like everybody else.
Yeah, and then as far as the 70-day trial date, I mean, it's a simple answer. They didn't file the Speedy
Yeah.
going into it, and frankly, there's nothing stopping them from filing it now, which is what we said earlier. I think where most of the resistance is coming with respect to the opinion is their view of Gull, and kind of their
Well,
opinion.
none of us know yet.
Yeah, I know. All right, so let's dig in.
So
Okay.
why don't we maybe get right to that section and not deal with, I mean, definitely don't deal with any section that deals with why they didn't grant if there's a page and a half of why they didn't grant the.
I mean, it's a pretty easy read. I mean,
All
I
right,
know
go for it.
it's really 17 pages.
I
But
know, and the people love it, so I'll stop
I mean,
fighting it.
I don't know how long you're gonna ask, like how long you're gonna continue to ask me stop reading shit, man. It's like I'm gonna read. Like
Gonna
maybe
read.
what I'll start doing is just like keeping you like off until I'm
Until
done
you're done
reading.
reading?
Yeah,
No.
yeah.
It's not me I'm worried about. I always think that maybe
I've
people
never
are like,
seen anybody say quit reading. Like if they
I know
want to
they
go to places that aren't reading, there's plenty of YouTubes that are not reading anything real, that are just speculating on the case. There's plenty of channels doing that. So, I mean, the people that like the reading, they come to us, they come to the Grizzlies, they come to, criminality. I mean, we're the ones who read the documents, the court documents. So if they're here, they want to hear it. All right. So we're going to start. The opinion dropped, as you guys know. The order came the day after the day of the arguments. So on January 18th, they issued the order. It was shocking that they issued it that quickly. Now we're getting the rationale on their decisions, why they reached the conclusions that they did. So the state charged Richard Allen with 2 counts of murder because he couldn't afford an attorney. The trial court appointed public defenders Andrew Baldwin and Brad Rosie to represent him. But after about a year, the special judge presiding over the case became concerned that they were not representing Allen effectively. So she DQ'd them over Allen's objection, replaced them with 2 new public defenders, and continued Allen's trial for at least 9 months so that his new trial attorneys would have enough time to prepare. Stevie, can you blow that thing up a little bit so people could follow along if they want? Allen then retained 2 appellate attorneys who filed a verified petition for writ of mandamus in our court, requesting that we mandate 1, that Baldwin and Rosie are reinstated, 2, that Allen's criminal trial begins within 70 days after they issue the writ, and then 3, that the new special judge replace the current special judge. Special judge and the attorney general both opposed the petition, and we held an oral argument, which you had many, many people watching you stream live. After considering all parties' excellent written and oral submissions, we granted Allen's request to reinstate Baldwin and Rosie, but denied his 2 other requests in short order with this opinion to follow. Here we explain our reasons for those 3 decisions. In short, we reinstated Baldwin and Rosie as Allen's court-appointed counsel because the trial court did not find that their disqualification was necessary as a last resort after weighing the evidence or weighing the prejudice to Allen. We denied Allen's request for a trial within 70 days because he did not make that request in the trial court. And we denied Allen's request to replace the special judge because he did not overcome our presumption of impartiality by identifying facts clearly showing that the special judge is biased or prejudiced. So that's like that particular section is what everybody's all up in arms with today. I've seen a lot of people that were upset. I'm not sure what their expectation was. I mean, this is right along the lines of what I thought it was going to be, in terms of when they didn't do it. I mean, they clearly read the briefs, they read what the allegations were, and they felt that it wasn't enough there because there is a presumption of impartiality. I mean, that they've got to twist that thing to the other side. They've got to push it all the way over, because that's the presumption immediately. That's the existing presumption. So if you've got to move it, and it's going to be a tough rock to move, so let's get into it. So the facts and procedural history: in February 2017, two teenage girls, Abigail Williams and Liberty German, were killed in Delphi, Indiana. 5 years later, in October 2022, Allen was arrested and charged with murdering them. The trial court judge transferred Allen to the Department of Corrections for his safety while he awaits trial. He then recused from the case. That's Judge Diener. A special judge was then appointed, and because Allen could not afford an attorney, the judge appointed Baldwin and Rosie to represent him at public expense. But a year later, the special judge lost faith in their ability to assist Allen with his defense effectively. So she ultimately DQ'd them as counsel. A leak of confidential case materials, including crime scene photos, triggered the DQ. Baldwin and Rosie represent that in August of 2023, one of Baldwin's friends and employees, Mitchell Westerman, visited Baldwin's office, secretly copied discovery materials, including crime scene photos, and distributed them to others. After discovering the leak, Baldwin and Rosie notified the special judge and the prosecutor on October 6th. They also explained that after Westerman told Baldwin on October 9th what he had done, Baldwin and Rosie relayed that information to the prosecutor next day. Now, note that they take notice of that fact, that they gave notice right away.
There's a couple other facts while you're reading this that, like you get a glimpse, a very strong glimpse of how they're, ways that are leaning towards the defense.
Way they're leaning towards the defense?
Yeah.
Well, shine some light. That's what you're here
for. When you get to it, I'll point it out. I thought that was, like you said, them noting the timing of that was more supporting the defense's way of presenting those facts than the state's, right?
Yeah, for sure. Well, I think we'll get to it. 2 days later, the prosecutor emailed defense counsel and special judge and allegedly provided the materials, committed suicide hours after refusing to.
You're choppy.
Am I gone? Yeah, I think my signal here sucks.
We can hear you now.
I don't even know. Yeah, I'm going to turn off my Wi-Fi on my phone because I'm floating. Let us know in the chat if I'm super choppy, because I might be. I am in I don't know where the hell Indiana, or not Indiana, but Tennessee. So,
Tennessee.
Let me see. Am I choppy? Somebody tell me.
No, you're good now.
I'm asking the chat, babe.
I could hear you choppy before, and now I hear you fine.
All right. Yeah, I'm concerned. Okay, the signal got a little better. All right. 2 days later, the prosecutor emailed defense counsel and the special judge informing them that the individual to whom Westerman allegedly provided the materials committed suicide hours after refusing to answer questions from an ISP detective investigating the leak. The special judge responded to the email by expressing that she was, quote, deeply concerned that Mr. Allen's defense is being compromised by all these recent events. She then directed defense counsel to stop working on the case until the judge could discuss the recent developments with the parties during an October 19th hearing. In the meantime, Allen wrote a letter to the special judge informing her that he had discussed the leak with Rosie and the impact it could have on his defense, but that he wanted Baldwin and Rosie to continue representing him. Counsel for both sides met with the special judge in her chambers just before the October 19th hearing to discuss the court's expectations for the hearing. During that meeting, the special judge informed Baldwin and Rosie that they had demonstrated, quote, gross negligence and incompetence, and conveyed that she had grave concerns about the representation of Allen. In support, the judge said that the attorneys failed to safeguard confidential case materials, including crime scene photos, that they emailed confidential work product to an unauthorized person and failed to timely report the leak. They made extrajudicial statements about the case and included inaccurate statements in various pleadings. Based on these concerns, the court informed counsel that she had decided to DQ Baldwin and Rosie. She offered to let them save face by withdrawing from the case so that she wouldn't have to go into a public hearing a few minutes later and read a statement that she had prepared explaining why she believed counsel was grossly negligent and ineffective. Alan wasn't present for this discussion, but after briefly speaking with Baldwin and Rosie, he relayed through them his objection to the court's DQ. Since
So
the
here it
court
comes.
presented, oh,
One of my, yeah.
you never made me, like, you told me not to say it. Like, you kept telling me, I'm like, oh, people are watching my shit because no one uses
That wasn't what I was going to say. I said that's leaning towards the defense.
Oh, okay. All right. Since the court presented to Baldwin and Rosie what seemed like a Hobson's choice, withdraw or be disqualified in a public humiliating fashion, they conveyed they would withdraw over Allen's objections to the court's disqualification decision. Special judge accepted their withdrawals and conducted a brief public hearing without them, where she stated that there was, quote, I love that they quoted this. Like that's a little thing when they quote that, an unexpected turn of events, and defense counsel had withdrawn from the case.
Wait, so I want to point that, re-say what you just said, like by the Supreme Court putting that in actual quotes, it's very meaningful. It's like they found that to be
I think that all of these things ultimately, now they're going to hang their hat on something completely different in terms of why they reinstated them. But clearly things like this, they were cognizant of, you know. But after having a few days to reconsider and discuss it further with Allen, defense counsel changed their minds, and neither Baldwin nor Rosie ever filed a written motion to withdraw as required by trial rule 3.1H. Instead, Rosie filed a verified notice of continuing representation, notifying the court that he, in fact, would not be moving to withdraw and would continue representing Allen. And he filed a motion to DQ on Allen's behalf, arguing that the special judge was biased and should recuse herself. The trial court struck both filings and ordered the clerk to remove them from the record because Rosie was no longer the counsel of record. She appointed 2 new public defenders to represent Allen. Excuse me. Baldwin then filed a motion to reconsider, also informing the court that he would not file a written motion to withdraw. He did not consider his oral withdrawal effective, and he would continue representing Allen. And Baldwin and Rosie both entered new appearances as Allen's privately retained pro bono counsel. But after a hearing on October 31st, the court entered an order stating that the judge, quote, previously found gross negligence by Baldwin and Rosie in the representation of the defendant, and quote, nothing has changed in the intervening 12 days that the court removes the court's grave concerns about the representation, end quote. So over their strenuous objections, the court disqualified them from representing the defendant and affirmed the appointment of new public defenders. The court also continued the January 8th, 2024 trial to October 15th, 2024. On November 6, 2023, Allen petitioned this court for a writ of mandamus by original action and asked us, 1, to order the trial court to reinstate Baldwin and Rosie as appointed counsel, 2, to begin the trial 70 days after the writ is issued, and 3, replace the special judge. They heard the oral argument on January 18th, and we issued a writ later that day granting Allen's first request but denying the other 2. Discussion. As we explained below, we agree with Allen that he is entitled to have his original court-appointed attorneys reinstated. But we agree with the state and the special judge that Allen is not entitled to a writ ordering a trial to begin within 70 days or replacing the special judge. 1, Allen's request to reinstate his original court-appointed counsel presents extraordinary circumstances warranting relief. So here they're going to deal with why they ended up reinstating them. Okay. But they're dealing with the procedural side of it first, meaning that hurdle that they had to get over because there was that argument that they didn't file their interlocutory appeal first, that they didn't take the critical steps that are typically taken before you go to the Supreme Court. And that in this situation, they found that it was proper because there wasn't going to be a remedy for them through an interlocutory appeal. So Allen argues that the trial court exceeded its authority by disqualifying his original court-appointed counsel because disqualification was unwarranted and significantly prejudices both the defense and his opportunity for speedy trial. I'm so happy to see them talking about the speedy trial side of this. It just seemed to get ignored to me in a lot of different ways. And I'm not talking about them asking the court for the 70 days, but the fact that what happened with this just completely obliterated that guy's speedy trial rights. I mean, like obliterated him to like where there's no way to fix it. Like now, I can't see a world in which they're going to be able to file anything speedy. You know, like now this thing's going to turn into your typical 2-3 year drag. You know, I mean, this it's going to be like every case of this magnitude that you typically see. It's going to take 2 to 3 years to get to trial because we're dealing with all this stuff. You know, and I don't see a way out of it. Like we're going to be a month out on just dealing with their motion for contempt, which this order clearly states can have no effect on Baldwin or Rosie. They can't, like, based on this order, there's no, everything that McClelland is arguing in his motion for contempt mimics everything that Gull was saying. He didn't add anything new. And they're saying that that wasn't enough, and we'll get to it. So like that contempt motion, aside from what the new, and I don't know if you saw the new motion, it was beautifully written. And it was basically a motion asking for summary denial of his motion to contempt. It's like 7 pages of gut punches. I actually have pulled it up, but because I'm having a problem sharing my screen, I had Stevie. I don't know if we'll be able to go through it. I'm definitely going to go through it. It's a beautiful piece of writing. It was really impressive. And it's somebody that we know, like a Twitter buddy that really did a great job. He's a professor at Indiana University. And he wrote a hell of a document there. He just threw his hat in the ring. I don't know if Baldwin and Rosie hit him up and like, yo, you want to take a stab at this thing or what? Or if he's just another concerned defense bar guy.
Wait, what do you mean? A motion to the Supreme Court?
No, he wrote a motion in the lower court. You know, it was
on there, like he wrote it for them and then they filed it?
It was on their behalf. It was an opposition to, it was a
like
reply.
An amicus.
Yeah, it wasn't an amicus. It's a response to
what's standing
the motion. Yeah, he entered his appearance. Like Indiana's the Wild West in a lot of different ways.
I don't even understand it. So I could just, if I was licensed, I could just file something in their case and interject myself like, hey, I'd like to be heard about what y'all doing in here.
I was surprised because Hennessy had re-entered his appearance, you know, but he's going to handle the actual hearing. Should it go to hearing, what Michael did is he filed a motion saying, look, McClelland's motion is hot garbage. You can't even bring it. Like it's not even like you can't even get to a hearing because it's like he didn't do anything that he needed to do. It's beautifully written.
All right, well, let's get through this and maybe people will want to hear that one.
Okay. Otherwise, I'll read it. So Allen argues the trial court had exceeded its authority by disqualifying his original court-appointed counsel because DQ was unwarranted and significantly prejudiced both his defense and his opportunity for the speedy trial. The state and the special judge respond that this original action is not the proper procedural vehicle to evaluate Allen's claim. And even if it was, the special judge was within her authority to DQ counsel because she was rightly concerned that they were not fulfilling Allen's constitutional right to effective legal assistance. All right, we agree with Allen. Our court has repeatedly reviewed attorney DQ issues through original actions, and we do so here because Allen's petition presents the sort of extraordinary circumstances for which there is not an adequate appellate remedy that our original action rules require. So that's what we're talking about. When they skipped the interlocutory appeal and went right to the original action, you know, the state really was fighting in on the grounds that procedurally they shouldn't have been there and didn't really get to the merits.
When so you say the state, you mean the judge, not the attorney general?
She's a state employee. Yes, Judge Gull. Correct. All right. A, we may review an attorney disqualification decision through an original action. So this court has original jurisdiction to supervise the exercise of jurisdiction by all Indiana courts. We exercise our supervisory authority through original actions for writs of mandamus or prohibition. Each writ is an extraordinary remedy, equitable in nature, and viewed with disfavor. A writ will not be issued unless the relator can show a clear and obvious emergency where the failure of this court to act will result in substantial injustice. It will also, quote, be issued only where the trial court has an absolute duty to act or refrain from acting. And finally, an original action, quote, may not be used as a substitute for appeals. So one issue that our court repeatedly reviewed through original actions is whether to disqualify counsel. They give a bunch of examples here. So issuing a writ to DQ a special prosecutor because the prosecutor's relationship with an attorney against who the defendant had recently testified created the appearance of impropriety. Declining to issue a writ to reinstate court-appointed counsel that the trial court DQ'd for their, quote, insulting and absolutely improper comments because the attorney had, quote, affirmatively requested that they be allowed to withdraw, quote, if the trial court denied the request for a continuance. And then declining to issue a writ requiring the trial court to withdraw its order DQing the elected prosecutor, where the elected prosecutor was a defense attorney for the accused in 2 prior cases. And then issuing a writ to remove private counsel retained for a state agency in violation of the statute. So when you're seeing the like an appellate court or the Supreme Court doing this, they're giving you examples of other times that they've handled it. That's why they're putting that in there. As in those prior cases, reviewing the trial court's DQ decision here is appropriate through an original action. That is because this case presents extraordinary circumstances where denying a writ will result in substantial injustice. And Allen's petition is not a substitute for an adequate appellate remedy. We reached that conclusion for a few related reasons. For starters, DQing Allen's counsel delayed his trial by at least 9 months. And the trial court has already concluded that Allen's pretrial confinement presents extraordinary challenges. Does it?
Wow.
And then she just won't move them. Normally, criminal defendants who must be confined while they're to await trial are detained in a county jail with other defendants who are awaiting trial or who have been convicted and received shorter sentences. But here, for Allen's safety, the original judge transferred Allen to the Department of Corrections, talking about Diener, which runs our state's prisons, facilities that generally detain inmates only after they are convicted and serving longer sentences for more serious crimes. The special judge later reconsidered the original judge's transfer order, and she found it, quote, reasonable and necessary to ensure the defendant's safety and to prevent serious bodily injury. Allen is currently being held at the Wabash Valley Correctional Facility, which is hours from Carroll County, where the charges were filed, and Allen County, where the special judge serves. Allen's original public defenders and his substitute public defenders have all challenged the conditions of his pretrial confinement, including as they relate to preparing his defense.
Sorry to interject. I should have waited. I thought you were at the end of that sentence. Did she have this before she ruled again denying the transfer?
So if you were to read through the tea leaves, so she issued her order 2 days ago. And if you read it very, very carefully, when she denies their motion to DQ, she puts in the order. She says that the Supreme Court has already ruled on this. I got to pull it up. I got to pull the order up because it's like it reads as if she had gotten this 2 days early by the way that what she stated in her order, which is ridiculous, but it seems as if it happened to me.
Well, do you want to? You want to keep reading and I'll email it to you and then
I'm going to read it right here. So the court this is Gull's motion from 2 days ago. So this is from February 7th. Okay. The court or was that yesterday? It's today the 8th or the 9th. The court having defendant's verified motion to DQ, defendant's affidavit filed January 28th, the certification of Richard Allen's attorneys filed the 28th, under advisement, and having considered the pleading, now denies the verified motion to DQ without hearing, as the Indiana Supreme Court unanimously denied defendant's previous request in January. So, like, I don't know. Like, how did she know it was unanimous?
I think
I
they
mean,
wrote that, and
did
they
they
wrote
say it
that.
was unanimous? All right.
Yes.
But for her to cite it is strange to me.
So
2 days.
blatantly, right.
Yeah. Okay. All right. So Alan is being held at the Wabash Correctional, which is hours from Carroll County, where the charges were filed and where the judge serves. Alan's original public defenders and his substitute public defenders have all challenged the conditions of his pretrial confinement, including as they relate to preparing his defense. We are in no position to evaluate the claims in those motions, and the special judge has concluded at least some of Baldwin and Rosie's claims about the confinement conditions are wrong. How would she know? Like, that's the thing with this. Like, she's basing her entire opinion on some warden who's never going to come in and be truthful about what's going on in his prison. Like, are
I
we
know.
living in a fantasy world?
I think
Like
so.
that whole concept is so befuddling to me. You know, I mean, like, look, she's supposed to be impartial. She's not supposed to have thoughts about whether Alan did it or not. You know, we have to assume that she really is concerned about his safety, you know, but when you have Cass County, that's a brand new facility, and they said that they take him, and it's closer for his representation to be able to get to him. I don't understand it. I don't understand it. To move him that far just seems crazy. It's a bad look. I can't get in Gull's head, but her to continually deny these things when everybody's concerned about his well-being and getting him to trial, and her just being just adamant to not move him is so weird to me. I don't understand it. I really
Right.
don't.
That's the part, like, if she was really concerned with his safety, once you have another set of lawyers saying, "Yo, this is not good." It's like,
But I like she at this point, we have to believe that she absolutely believed the warden at Westville, and that what she saw with regards to Wabash Valley wasn't the things that rise to the point where she feels like she needs to move him. I don't know. I mean, I'm not trying to make excuses for her. I'm trying to understand it, you know, and it's hard to understand. I mean, if he dies in custody, the whole world's going to explode. All
the family might
right.
have a pretty
So,
good wrongful, well, there'd be some immunity there, but you know what I mean.
but even assuming every aspect of Alan's pretrial confinement is proper, and again, we're in no position to say one way or another at this point. At this point, extending it for at least 9 months still presents extraordinary challenges for which there is no adequate appellate remedy. What's more, as we explain in greater detail, we've concluded that the trial court lacked the authority to remove counsel without, one, considering other less drastic options, and two, with weighing the prejudice to Alan. So not only would Alan's trial be delayed for at least many months if his original attorneys were not reinstated, if Alan were convicted, correcting the disqualification by vacating his conviction and ordering a second trial would produce years of further delay and an enormous waste of time and resources. That would not serve anyone's interest, not Alan's, not the state's, not the victims' families, the courts, nor the public's. Of course, these concerns can generally be resolved through discretionary interlocutory appeals, including as a basis for a discretionary interlocutory appeal that the quote appellant will suffer substantial expense, damage, or injury if the order is erroneous and the determination of the error is withheld until after judgment, end quote. Or, quote, order involves a substantial question of law, the early determination of which will promote a more orderly disposition of the case, end quote. And both the state and the special judge argue that that is the procedural route that Alan should have pursued instead, but Alan effectively couldn't, which is another reason that this matter is extraordinary. So on top of DQing counsel, the special judge struck their later filings because they were no longer counsel of record without the ability to file a motion requesting the special judge to certify her order for interlocutory appeal. Now, this is what you and I were talking about, like trying to figure out how the hell like mechanically he could file the interlocutory appeal. You know, it's like Screven and Labrador are going to have no interest whatsoever in removing themselves from the case. It's a kingmaker case. I keep saying it over and over and over. We've seen Labrador post, you know, him being booted. He still wants on the case. It's a kingmaker case. It is a career maker.
I don't know if I did that and I did it by accident or if one of the mods did, but is that an actual possible thing? I'd be surprised. Did Baldwin and Rossi file again
Rosie.
at the Supreme? Rosie.
Not that I'm aware of, Chloe's mom. I mean, what we're reading right now is the opinion relating to their order from January 18th. So Supreme Courts will, you know, give an order, but then they'll back it up with rationale, you know, and their reasoning and as to why they made decisions. So that's what we're reading now. I don't know if you're confusing that. I have definitely not heard of anything. Like I'd be getting blown up
muted.
some kind of massive file. Let's see. Okay, yeah, Nicole. All right. Okay, to that point, the state and the special judge responded that Allen should have had either his new public defenders or the appellate attorneys he retained for this original action pursue an interlocutory appeal instead. But it isn't clear how either option was feasible. The newly appointed trial counsel had nothing to do with the DQ proceedings, and Allen wasn't present for them. So it is not now obvious how Allen could work with his new trial attorneys to pursue an interlocutory appeal in the trial court. Maybe Allen's privately retained appellate attorneys could have done so, but it's unclear whether the trial judge would permit them to represent Allen in the trial court along with his new substitute counsel. And it's unclear how it would work if substitute court-appointed trial counsel, disagreed with the privately retained appellate counsel about whether to seek certification in the trial court. We simply don't expect Allen to untie that procedural knot, and he can cut through it with this original action instead. Our prior precedents pointed appellate counsel to the original action tool, and we decline to retire that tool for these sorts of situations now. Having concluded that Allen's petition was properly before us, we then turn to its merits. So B, Allen is entitled to reinstatement of his original court-appointed counsel. Court-appointed counsel may be DQ'd only as a last resort after considering the prejudice to the defendant. So the
you mean not for like just grossly negligent? Do they ever mention that that's not the standard?
I guess you're gonna have to wait and find out. Okay. Exciting, isn't it? So exciting.
Yes, it is.
The Sixth Amendment to the U.S. Constitution through the 14th Amendment's due process clause via Gideon v. Wainwright and Article 1, Section 13 of our Indiana Constitution guarantee criminal defendants the right to have an attorney assist them with their defense. And then U.S. Constitution Amendment 6, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. Indiana Constitution, Article 1, Section 13, in all criminal prosecutions, the accused shall have the right to be heard by himself and counsel. For defendants who can afford to hire an attorney or retain an attorney to represent them for free, that constitutional guarantees includes the right to choose which attorney which will represent them. And that's Gonzalez. That's the case that you love so much. That was like you knew as soon as the judge was throwing Gonzalez around out there, it was done. In the erroneous deprivation of his rights constitutes structural error, which, unlike other errors, entitles criminal defendants who are convicted to automatic reversals in a new trial. But the right of counsel of choice does not extend to criminal defendants who can't afford an attorney and can't find one to represent them for free. Allen can't afford an attorney, and he had asked us to reinstate Baldwin and Rosie as his court-appointed counsel. Consequently, he had no constitutional right to choose which attorneys will represent him, but he didn't choose Baldwin and Rosie. The trial court did. Allen just wants to continue with the attorneys the trial court chose for him. He is insisting on the continuity, italicized,
nice,
of counsel rather than his choice, italicized, of counsel. Courts around the country are divided over whether the Sixth Amendment guarantees criminal defendants the continuity of court-appointed counsel. It's funny. I remember somebody I know saying that,
Yeah.
and it wasn't Brett.
Right.
It's you. There is no constitutional right to continuity of counsel of appointed counsel in that state v. McKinley and Iowa case. Once established, the interest in maintaining a relationship of trust with counsel is of no less importance to an indigent client than one with ample resources to hire counsel. I mean, that's what it gets down to, right?
Yes.
I mean, it's
Bravo,
absolute
Supreme Court.
bullshit that, people with money who have to be appointed public defenders, that they don't have the same advantages to people with money. I mean, it shines such a bright light on the inequality of our judicial system and our criminal justice system. Like, just that alone is such a bullshit move. Our court has, quote, generally of the view that the trial court is limited in its authority to remove a criminal defendant's court-appointed counsel, and that's State ex rel. Jones, which was the case that everybody was citing coming in, especially like Shay Hughes was
and the guy that sent us all that stuff, he's been telling me Travis, right?
Someday you'll learn
Jones as well, but I know it don't feel bad because it's my brain.
No, it's true. She calls all her kids the wrong names constantly too, which they love. They find it very endearing.
I think a lot of mothers. I remember my kids' names.
You remember their names, you just assign them to the wrong kids a lot. And even courts that have concluded that there is no Sixth Amendment right to the continuity of court-appointed counsels have agreed with that much. For example, the Colorado Supreme Court recently held that there is no Sixth Amendment right to the continuity of court-appointed counsel. It still acknowledged that, quote, a defendant's interest in continued representation by a lawyer that they've been working with is entitled to great weight if they can demonstrate that prejudice would result from substitution with a different court-appointed attorney. So they're bringing in at least the balancing. It's like you see the scales of justice whenever you talk about the law, and you see, the scales of justice in the statute. That's what you're talking about. Like, in the law, balancing is a thing that is done a lot. And that's what they're talking about there. And that's why you hear the word weight used a lot in the law. Weight is a big thing in the law because of that balancing. People v. Rainey. And then the court concluded that interest flows from the due process guarantees in the 5th, 14th amendments to the U.S. Constitution rather than the 6th Amendment right to counsel. And while the U.S. Supreme Court has not addressed whether there is a Sixth Amendment right to the continuity of court-appointed counsel, it too has recognized that the rights to due process and counsel overlap.
Yes.
And that's Strickland. So
what?
The service is calling. Got a case.
I have mine on Do Not Disturb, so I don't know.
Oh, nice. Okay, the Constitution guarantees a fair trial through due process clause, but it defines the basic elements of a fair trial largely through the several provisions of the Sixth Amendment, including counsel clause. Colorado Supreme Court, they must have liked the Colorado Supreme Court decision. It's getting a lot of like page space here. Old Colorado, Supreme Court of Colorado. The Colorado Supreme Court also recognized what?
No, it wasn't important what I was going to say anyway. I was going to say just it seems like because Colorado, they recognize that there is no constitutional right under the federal constitution, and then brought this other thing in. So it's more like right in between the people who say you do have that and you don't have that.
Yeah, no, I feel that. All right. So Colorado Supreme Court also recognized that before disqualifying court-appointed counsel, that the court must determine that any remedy short of disqualification would be ineffective. In other words, DQing court-appointed counsel is a drastic remedy that should only be a last resort, which obviously they love that language, which comes from Ellis, which is a Tennessee case, because they were talking about it. Like, that's like when they're first coming out, they're saying it's got to be a last resort. Like that's what Indiana's position is on it. That you're just not bouncing lawyers. It's got to be, you got to go through a lot of different things before you start to bounce a lawyer. Courts should therefore DQ counsel with considerable reluctance and only when no other practical alternative exists, and that's U.S. v. Gearhart. Thus, DQ of defense counsel should be a measure of last resort. The government bears a heavy burden of establishing that disqualification is justified. And this approach aligns with how we have treated other drastic litigation remedies that are in tension with parties' due process rights. Like, do you think that you could break down, like this is what people need from us? Can you break down what they're talking about with respect to?
Yeah, read it again so people know what I'm about to tell them about.
Okay, so I'm going to start from back here. So it says disqualification of defense counsel should be a measure of last resort, and the government bears a heavy burden of establishing that disqualification is justified. And this approach aligns with how we have treated other drastic litigation remedies that are in tension with parties' due process rights.
Right. So generally, you know, your due process rights include like your right to a fair trial, your right that nothing can be taken from you, your life, liberty, you know, without due process. Well, the court here is recognizing that even our Supreme Court has said that the right to counsel overlaps with your due process rights. So I think that's what they're saying, is that they take cases where due process is at issue seriously. And I don't know, is there more than that, babe?
No, that's good. While the state defends the DQ decision here, it appropriately acknowledges that a trial court's discretion to DQ court-appointed counsel is significantly limited. The state's brief accurately explains that while, quote, varied interests may necessitate overriding a defendant's preference, DQ is an extreme remedy that should only be used when a court deems it reasonably necessary to ensure the integrity of the fact-finding process, the fairness or appearance of fairness at trial, the orderly or efficient administration of justice, or the public trust or confidence in the criminal justice system.
And if there's gross negligence.
And if there's gross negligence. They didn't add that one to it.
Oh, damn.
So whether it's a product of a defendant's right to due process or right to counsel, the bottom line is this: a trial court cannot disqualify court-appointed counsel over the objection of both the defendant and appointed counsel unless A, disqualification is a last resort, B, DQ
Gross
is necessary.
negligence. Oh, sorry.
That's D.
Okay.
B, disqualification is necessary to protect the defendant's constitutional rights to ensure the proceedings are conducted fairly and within our profession's ethical standards, or to ensure the orderly and efficient administration of justice. And C, those interests outweigh the prejudice to the defendant. Okay, in a previous original action, we said a trial court is, quote, limited in its authority to remove a criminal defendant's court-appointed counsel, but we went on to say that it was, quote, unnecessary to explicate the parameters of that authority and state XRL Jones.
But we're going to do that shit now.
Right, well, they're doing it now. Well, while an original action is not the appropriate vehicle through which to adjudicate or establish a right or to define and impose a duty, here we do find it necessary.
What the hell, dude?
Getting blowed up.
Turn that on. Do not disturb. You've got people.
Oh, sorry.
Say hi to the people.
Hi, peoples. All right. Here
So,
we do not find it necessary.
Since we did the little break, let me just say what they're saying right there. Like, look, this is not really the right avenue for this. This isn't really what we do. But you know what? This shit warrants us doing it right now.
Right. Exactly.
I can hear you typing. You need to put that on.
No, I was texting Dizzy because Dizzy was letting me know. Dizzy's one of our mods and one of my ride or dies. That she was letting me know that we have all the documents in our Discord.
Nice. All right. Sorry. I will so try to not keep interrupting you.
No, it's good. I mean, we're almost done, dude. You're acting like it's 400 pages long.
No, I'm not.
Okay. I'm whipping through this thing. Well, I can hear all my friends having fun out there. All right. Here we do find it necessary to explain the parameters of the previously established limitations on the trial court's authority. The framework we describe here mirrors how our court has treated other drastic remedies that may conflict with parties' due process rights. and our concern that disqualifying counsel introduced structural error, at least as it relates to disqualifying them as privately retained pro bono counsel, which was exactly what you had said. Presents further extraordinary circumstances that prompt us to exercise our jurisdiction now to preserve the integrity of the trial proceedings going forward. Okay, so 2, DQ here was not a last resort. The special judge concluded that Baldwin and Rosie made 4 mistakes that demonstrated that they may be unable to assist Alan with his defense effectively. 1, they failed to secure confidential case materials, including crime scene photos. 2, that Baldwin misdirected an email, he says inadvertently, with confidential case materials to a non-party client without timely reporting. See, there's what popped up. So you remember how I was saying that they timely reported the bigger leak? They noted here that it wasn't timely reported with respect to the smaller leak of the index, the evidence index. Without confidential case materials to a non-party, without timely reporting the mistake to the trial court or the prosecutor. 3, Baldwin and Rosie made extrajudicial statements while the prosecutor's motion for a gag order was pending. So did he. 2 days prior to theirs. Which the special judge thought might prejudice the case. And 4, statements in Baldwin and Rosie's motion to reconsider safekeeping order turned out to be wrong. Respondent, also that's the site, but the record does not reflect the special judge DQ'd counsel only as the last resort after balancing. There's that word again. The scales of justice.
Gross negligence weighs like, I don't know, like a feather.
I mean, in civil court, it's super heavy. In civil court, it's a super heavy, it's like a big piece of lead. In criminal court, it doesn't exist.
It's just a feather. It's a tissue.
Oh my God.
Why is the sound not
I put it
off
on
yet?
focus. I don't know, dude. I don't know. I put it on do not disturb. It's not working. But the record does not reflect the special judge DQ'd counsel only as a last resort after balancing her effective assistance of counsel concerns against the prejudice to Allen that would result from substituting counsel. Of course, this goes back, they're not bouncing her due to the fact that, and we'll get to it, but the one thing that we know is that they were not thrilled with the record. And it's like this thing here where they're talking about, they wouldn't know if she balanced it because she doesn't keep a record. There's nothing on the record. She writes these minute orders without citing law or giving any kind of just so you all know. Now, this is obviously extreme. It's the Supreme Court. This is a lengthy opinion, but even from a trial court judge, like a good trial court judge will issue an order like this, where they'll give their reasoning behind their decisions. They'll cite case law. They'll cite, statutory law. Gull doesn't do that. And when she does, she appears to cite the incorrect law with respect to the standard.
Gross negligence.
Not even it's even more than that.
I know, but that one just
like what she denied the Franks motion on was the wrong standard.
Are you kidding me?
No. Okay, so first, the record does not reflect that disqualifying counsel was the last resort. Each of the special judge's 4 concerns could be addressed through a combination of procedural rules and court orders, including the gag order and protective order she entered. And trial courts maintain both statutory and inherent authority to compel compliance with their orders and the procedural rules through contempt proceedings and sanctions that include fines and even jail. And again, we'll remind everybody, Hennessy, when he drafted up his response in anticipation that they were going to try to DQ him, that's what he suggested. He said, hey, have him go 7 days without pay. Somewhere 8 to 10 grand, probably more cumulatively between the two of them. They'll feel that. They probably won't forget to lock up the evidence again. Okay, and then they cite some more cases, recognizes McQueen v. State, recognizing that a trial judge can protect the court against insult and gross violations of decorum by the infliction of summary punishment, by fine, imprisonment, or both. via contempt citation, contempt statutes. Indeed, the trial court's protective order invoked the court's contempt power to enforce compliance, ordering that the parties cannot grant anyone access to discovery materials without the court's permission and without the person seeking access first signing an agreement subjecting them to the court's contempt powers, end quote. There was no finding that these tools were inadequate to resolve the special judge's concern. Like that was my thing. Like, we know Westerman pimped these things. Like it seemed like Baldwin could have turned around and said, well, this is a guy that I was strategizing with. Like, the guy has a law degree, he worked with me, he's a friend. I respect his opinion. I like the way his mind works. I was throwing my theories and strategies at him, and it's like,
all legit.
There could have been an argument that, he fell under the gag or the protective order, and then she could have.
He definitely fell under the protective order, I think.
Well, I mean, and that should, like, if she wanted to get somebody, like the real bad guy, not
no,
just
but they would have had to give it to him, get him to sign it.
Right.
That never happened.
And then get it to the judge. The judge would have had to approve it. There was no finding that these tools were inadequate to resolve the judge's special judge's concerns. So second, the only basis for disqualifying counsel was the special judge's concern that they could not assist Allen with his defense effectively. To be sure, the Sixth Amendment right to effective counsel, quote, imposes a baseline requirement of competence on whatever lawyer is chosen or appointed, and that's Gonzalez v. Lopez. But there is no suggestion that Baldwin and Rosie are out of their depth. Baldwin, except for the fact that she called him grossly negligent. That's her suggestion. So, but there is no suggestion that Baldwin or Rosie are out of their depth. The only thing I would have loved more about this section of this is if they would have cited the state that they acknowledged that both Baldwin and Rosie were highly competent attorneys. Baldwin has over 30 years of experience representing thousands of clients around the state, including clients charged with murder, rape, robbery, burglary, and other violent offenses. And he has tried more than 125 jury trials. It's a shit ton. Rosie has over 20 years of the same experience, including 3 murder trials and a previous certification to handle death penalty cases. Moreover, neither the state nor the special judge argued that counsel's extrajudicial statements or the statements in their motion harmed Allen's defense. They do argue the disclosure of case materials undermines Allen's defense, but they don't explain how. And they don't argue these mistakes reflect that Baldwin and Rosie are incompetent to handle Allen's defense or explain why disqualification is necessary, italicized, to protect Allen's right to the effective assistance of counsel. Notably, neither the state nor the special judge direct us to any case concluding that issues like these, either in isolation or in combination, rendered counsel constitutionally ineffective or were sufficient to warrant disqualification. Third, there is no showing that the special judge concerns outweighed the substantial prejudice to Allen from substituting counsel. Baldwin and Rosie spent a year working with Allen, investigators and experts, developing Allen's defense, and Allen says that he's ready to present it to a jury. The prejudice to Allen begins with the fact that information and momentum spillage is inevitable as one trial team hands a complicated case like this over to another. Add to that, Allen has already been in jail for about 1.5 years now, and substituting counsel requires were you going to say something?
I just said prison.
Oh, yeah. Right. And add to that, Allen has already been in jail for about 1.5 years now, and substituting counsel requires a 9-month delay in the trial date, which with substitute counsel, unsure whether they would even be ready by then. That is not surprising, given that this is a complicated, high-stakes case. Further, it has already been 7 years since the murders, and fact-finding only gets harder as time passes, memories fade, and evidence is lost. Our disciplinary rules, and their citing matter of peoples, our disciplinary rules recognize that with the passage of time, clients risk the loss of rights, witnesses' memories fade, and evidence may disappear. The record does not reveal any weighing of these concerns. Excuse me. Because the court does not reflect disqualification was a last resort that was necessary after balancing the trial court's concerns against the prejudice to Allen, Baldwin, and Rosie must be reinstated. Okay. Allen's remaining requests present no extraordinary circumstances warranting relief. Allen's second request is what we mandate that the trial court order Allen's trial to commence within 70 days. Allen is an attorney.
Oh, no, you're breaking up. You're breaking up. I don't even think you can see me.
Can you all see us?
Or is it me?
We still here? All right.
It was
Allen's
just you,
second
I
request
think.
was mandate that the trial court order Allen's trial. Allen and his attorney motion. They never filed it with the trial court until a trial. What?
You're
Huh?
we can't. You're super choppy, and now
I don't
you're.
know.
Can you hear me, babe?
Am I? I'm frozen. They're saying I'm frozen. Still freezing.
Well, now you're not.
There's nothing I can do about it. The internet's what it is out here. Nah, I'm in noodles. I'm in, like I've said this 3 times now. I'm
He's
in
on a
routine.
boys'
It is
trip.
what it is. I wanted to jump on.
Tennessee
If it's so
for the
bad,
Super
I'll
Bowl.
bounce. I'll bounce. Yeah. But
You guys
rural
don't like it, I'm
Tennessee,
out. Huh.
No, I'm just saying if it's not
I know.
working, I could try to turn
No,
off
you're.
my camera.
You
See if that
seem good
works.
again.
Is the sound good though? Is the
It
sound
wasn't.
good?
It is
I don't
now.
necessarily care about this. Okay.
No,
all
the
right.
sound. It's
Good. We're getting close. Is it choppy or no? Is it good? I don't know.
It's good
All
again.
right,
I
I'm going to
guess.
read
Yeah.
it. I mean, Allen's second request is that we mandate the trial court order Allen's trial to commence within 70 days. Like I read all this. Okay, until a trial court has refused to rule properly, there is no basis for relief in this court. We therefore deny Allen's request to order that his trial begin within 70 days, although his attorneys remain free to make such a request in the trial court if Allen wishes. That's what I'm saying. They absolutely can go forward and simply make the 70-day demand. So Allen's third request is that we appoint, this is where everybody's all up in arms. Allen's third request is that we appoint a new special judge to avoid the appearance that the trial court is biased against the defense. But Allen has not stated facts showing clearly that the judge's disqualification is required. We begin with the presumption that a trial judge is unbiased, and that comes from Smith v. State. To overcome that presumption, and this is the rule, folks, to overcome that presumption, the party seeking DQ must identify facts reflecting the judge's actual bias or prejudice. Our law is well settled that, quote, prejudice is not inferred from adverse judicial rulings. And that is all Allen identifies here, that the special judge adverse ruling disqualifying counsel, which is true.
No. There were her removing things from the record, her not file. Like there was more
was
than
that
just
bias though. I mean, it was certainly. I don't know what it was. She's been trying the case in the shadows the whole way. I don't necessarily know that was because of Baldwin and Rosie. You know what I mean? I think she gagged. I think any judge would have gagged this. Right? And I'm not making an excuse for Gull because everything that she's done, my point is that everything that she's done since they were reinstated, to me is screaming bias.
Well, it's the same thing.
It's not the same thing. It's not the same thing. Her denying motions without hearings.
Right.
They're dude, it's not the same thing. She hadn't done anything really of substance. Now she's done all kinds of substantive rulings without hearings. Now to me, it looks like bias. Back then, maybe not. But in terms, the court's clear that her DQing them, in her mind, she thought that it rose to the level, I guess. I mean, obviously we didn't agree. And obviously that the Supreme Court of Indiana doesn't agree that was enough to bounce her. So let's see what they say. All that is all Allen identifies here. The special judge's adverse rulings DQ counsel. No doubt that adverse ruling was significant. but nothing in the record suggests that the special judge's decision emerged from bias or prejudice against Allen. Just the opposite. The special judge explained that she DQ'd counsel because she was trying to protect Allen's right to the effective assistance of counsel. Gross. It's a gross thing that they're saying there. And we don't minimize her concern. She faced a significant dilemma given her conclusion that defense counsel were no longer effective. If she left counsel in place and Allen was convicted, the conviction might have been vacated through post-conviction proceedings based on ineffective assistance of counsel. Or if she DQ'd counsel and Allen was convicted, then the conviction might have been vacated because she infringed on Allen's right to the continuity or choice of counsel. She was in a tough spot either way. I don't think she thought of it. I don't think that she took that into consideration at all. I don't think that was part of her analysis at all.
You have to be inept for it not to be. I mean, it's the right to counsel, for God's sakes. I don't get it.
See, but like, and I understand what you're saying, and as a general proposition, I would agree. However, what she has done subsequent to the order reinstating them flies in the face of logic, and it flies in the face of that argument. The Supreme Court unequivocally said, your record is for shit, lady. Get it right. Do it right. And what does she do? She then comes out, and again, and we've talked about this multiple times. The Franks hearing, you're right. I mean, like, she could deny that without a hearing. The ballistics, there's no way. She's got to have a hearing on the ballistics. Even if she's denying all of them, I mean, you have to make a record.
Exactly. I mean,
she
it's
just
like
refuses to make a record. Like, that's what my concern is. People are like there's the denial part of it, and then there's that she just isn't making a record. She's not giving them hearings. That's where the bias is, not the fact that she's denying the motions. Look, as defense attorneys, we can tell you, we get body slammed on motion work all the time, every day.
But the judges still go through the motion of having the hearing.
Right.
Right.
Okay, so, or if she DQ'd counsel and Allen was convicted, then the conviction might have been vacated because she infringed on Allen's right to the continuity of counsel of choice. She was in a tough spot either way. Though we've determined the record does not support her DQ decision, we reached the conclusion with the benefit of weeks to consider the issue. Thorough briefing and oral argument from excellent appellate attorneys. Yes, Karen and Mark were excellent appellate attorneys. And the benefit of the 5 justices and their staffs poring over the records, authorities, and argument. The special judge did not have those luxuries, nor does Allen point to anything suggesting the special judge is biased against Baldwin and Rosie. Of course, she said their mistakes reflected gross negligence. There it is. And she was concerned that their representation was ineffective. But, quote, judicial remarks during the course of a trial that are critical or disapproving of, or even hostile to the parties or their cases ordinarily do not support a bias of partiality, a bias or partiality challenge. That is, unless they reveal an opinion that derives from an extrajudicial source or reveal such a high degree of favoritism or antagonism as to make fair judgment impossible. Look, the special judge said counsel made mistakes that rendered their representation ineffective, but her statements were not based on any extrajudicial source or any experience outside the case. Instead, her statements were based entirely on her observations within the case. And while her conclusions, the counsel were constitutionally ineffective, was too harsh, she wasn't wrong to be deeply concerned with that sensitive case materials had leaked. Though she mistakenly hit defense counsel's eject button, boop, instead of the case's lockdown button, boop, she was right to try to get the situation under control quickly and decisively. Her efforts did not reflect any bias or prejudice, and Allen does not identify anything that she has done that demonstrates that she isn't impartial. We therefore deny Allen's request to replace the special judge. Okay, so that's it. Having granted Allen's request to reinstate, blah, 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 this opinion terminates the original action. So we had 4 concurring, and Slaughter concurs in part with dissents in part with a separate opinion. So I'm not going to read. Like, does anybody want me to read Slaughter's dissent?
Dissent?
Yeah, Slaughter was the only one who dissented.
Maybe just read the little summary, like the wrap
right.
up.
And it's not unusual. Like when you have higher courts where you have multiple judges, Radar saying read it. Easy for you to say, Radar. All right. So in when you have appellate or Supreme Court, all the judges, it doesn't have to be unanimous like a jury does. It's a majority. So a majority allows it to pass, or it allows that opinion to become the law, especially with the Supreme Court. And here at the state level, it's the same thing. It was a 4-1 count. Slaughter was the only judge who dissented, but the majority won the day. So he says Relator Allen fails to meet the demanding threshold for obtaining extraordinary relief he seeks. He establishes neither the respondent's breached a clear legal duty entitling him to the unquestioned relief, right to relief, nor that an ordinary appeal. So he's going on the procedural. He's not even getting at least
I said that. I said that on the thing with the prosecutors. I said, I guarantee you it's procedural.
Yeah. And we could tell immediately that's what it is. So he establishes that neither the respondent's breached a clear duty, legal duty entitling him to an unquestioned right of relief, nor that an ordinary appeal would provide an inadequate remedy. Thus, I concur with part 2 of the court's opinion, which denies Allen's request that we replace Special Judge Francis Gull and order a trial within 70 days. But I respectfully dissent from part 1, which orders the reinstatement of Allen's court-appointed counsels, Andrew Baldwin and Brad Rosie. My objection has less to do with the court's legal analysis than it does with the bottom line issuance of a writ, given the procedural posture in which the issue of an attorney disqualification comes to us. Had this issue arisen in an interlocutory appeal or after final judgment, I would be more open to Allen's argument that the trial court erred, threatening to DQ his trial counsel after finding them grossly negligent and incompetent. But that is not the posture of this case. By seeking relief through the vehicle of an original action, Allen takes on the onerous burden of satisfying its exacting requirements. Original actions are viewed with disfavor and cannot serve as substitutes for appeal. We do not issue writs to establish rights or define duties. A writ is warranted only to force an official to perform a clear legal duty or to grant an unquestioned right to relief. A writ will issue, in other words, where the trial court has an absolute duty to act or refrain from acting. Okay, so first he says the trial judge did not violate an absolute duty in dismissing court-appointed counsel because Allen does not have the unquestioned right to keep them. So he does get into the merits a little bit. The Sixth Amendment protects Allen's rights to effective counsel. Cites Wheat. He's the Wheat guy. Wheat. The Sixth Amendment protects Allen's rights to effective counsel, Wheat, which includes his choice of qualified counsel. The right to counsel of one's choice, though, is not absolute, but is circumscribed in several important respects. Trial courts have wide latitude to balance this right against competing interests like fairness or profession's ethical standards and the court's scheduling needs. And then he cites Gonzalez. The essential aim, that was Gonzalez he was saying, the essential aim, after all, is to guarantee an effective advocate for each criminal defendant and not to ensure the defendant will inexorably be represented by the lawyer whom he prefers. While the trial judge's actions raise a potential constitutional problem, under current law, it is far from clear that she's exceeded her authority. So he gets to the merits of it a bit. He does both.
I mean, all he really said there, I mean, I was starting to be like, damn, why did he have to go through the merits? But all he really said there was because it's not like the law is 100% resolved that you have the right to continuing counsel, that it's not a clear right. So it's still technically procedural. Technically.
One of each. Yeah. Thanks, Cor.
Where'd you go? Oh, because your picture's not there anyway. So then it seems like I'm just talking to myself. Yeah, you can go back on. I don't think that was the issue.
I was
Put your
breaking.
face back
I
on.
was breaking. It might. I'm trying.
It's still breaking up.
Wheat. All right. The court's opinion, like it's like I think it was my camera. It's like struggle busing.
Well, who knows if we've officially lost him now or he doesn't even know. Um, but while he is gone, somebody asked, and I can't find the comment to put it up anymore, like, what is an example of bias? And, that it's obviously hard to put an example on it because it's sort of like, what they used to say about pornography. I'll know it when I see it. Bob and I actually did have a judge. He yelled like he's got a temper, and he yelled and he screamed and like called us liars, read from our website, which is extrajudicial. It's not part of the thing. And then on the next case that we had in front of him that we were going to do a bench trial, I didn't file an official motion, but I said, "Do you think that you can be fair to this defendant in light of your, I didn't have to say much because he knew what I was getting at. And he didn't even see his own bias there. But to make that story go full circle, he later called Bob and I a huge asset to the defense bar. But, they get it wrong sometimes. Sometimes they admit it. Man, Bob's not even connected. All right, here's what we're going to do. Those of you who know me know I do not like being on alone. Plus, I seem to be getting a bit of a cold, so we'll do this. Every time I see something new, I have to hear what Bob and Allie have to say. I love how they explain everything, and I feel smarter after listening. Well, thank you very much. Thank you, thank you. So we'll answer questions. Do you think Gull had a heads up on the SCOIN opinion, and that's why she denied those DQ requests without a hearing? So Bob obviously felt the exact same way, Candace. He thought that her being so blatant about it, while the opinion is sort of pending, that she knew. But we'll never know for sure. So Aspen asks, how long before the defense files a new writ? So that's what we were talking about before. I don't think that that's something that they could. I was answering questions since you
Disappeared.
fell out. Yeah. But let me just finish this one, and then I will let you do your thing.
Love you.
Corey, because
he's a gentleman.
Sort of what the dissent was saying, like you only use this avenue when it's really important. And I don't think that I don't think that would be the failure for her to disqualify herself would be something that they could do a writ for. I think they'd have to actually do a regular interlocutory appeal. But that's just one lawyer's opinion.
Wheat. All right. Good. It sounds like you were having good discussions. Yeah, I logged back out, ran up and got my charger. I think that helps a little bit. All right. So we were I'm not going to read that part. He says, and then having announced its new rule, the court proceeds to find that the trial judge breached it. The problem is that this rule did not exist previously. The opinion
what rule? Continuing counsel rule? Is that what he's talking about?
All right, I'll reread it because it seems like everybody forgot what I was reading. Okay, the court's opinion tacitly admits as much. To justify its award of relief, the court must fashion a new rule against which to adjudge the trial court's actions below. So a court cannot DQ court-appointed counsel over the objection of both the defendant and appointed counsel unless A, DQ is the last resort, B, so that he's rereading the rule.
He's saying that's new law, but it's actually exists in, I've read similar in, federal circuit, federal cases, but.
Okay. So, I mean, he's citing the rule that they just made. So he says, and then having announced this new rule, the court proceeds to find the judge breached it. The problem is that this rule did not exist previously. The opinion cites nothing from our court or any court establishing this rule. Yet, despite being unable to identify the source of the rule imposing the supposedly clear legal duty, the court awards extraordinary relief anyway. The court is not even sure of the rule's constitutional source, be it, quote, the defendant's right to due process or the right of counsel. The existence of such a duty is anything but clear. If the court must patch together its rule out of whole cloth, I love that saying, I use it all the time. So if it must patch it together its rule out of whole cloth to justify today's result. On the merits, I do not necessarily quarrel with the rule that the court announces today. It appears to strike a reasonable balance. There it is again. Between the competing interests of a criminal defendant's right to counsel and a judge's duty to ensure the defendant receives a fair trial. My beef, it's got a beef. Rather,
wait, he says my beef?
My beef. I got a beef. I liked, they had some fun language in there. He says my beef. They talked
the other guy's
about,
like, look.
They talked about the eject button, the eject button, you know, boop. My beef rather is with our after the fact application of this newly minted rule to award mandamus relief against Judge Gull, who did not have the benefit of our rule when she acted. For this reason alone, I cannot join part one, our original action. Rules do not permit issuing a writ when the trial judge's duties are unclear or the law is unsettled. Original actions are for clear-cut cases that apply settled law, not for cases like today's that announce new legal rules. The latter is what for appeals are for. Second, Allen does not make the case that an appellate remedy would be inadequate. This case could and thus should have been brought in as an ordinary appeal. Instead, by issuing a writ, we ratify Allen's improper request for a shortcut to an appeal on the merits. And Allen could have sought a discretionary interlocutory appeal under Appellate Rule 14b when the trial judge dismissed his counsel and barred them from entering a pro bono appearance. There was no reason to presume Allen's original action counsel could not have pursued such an appeal on his behalf. Allison was knocking at Kara's door. You sure you don't want to file the interlocutory appeal? At least file the notice. Do the note, file the note. Slaughter would have appreciated you trying to do that. There is no, dude, I'm on seriously on live with like 1,000 people. Come on, man. Like Fifi's on fire. He was mooning me outside this window on her. Right. Come on, man.
No,
seriously. Yes, I did. And the world did too.
I did. It wasn't cute.
Maybe. There's no reason to presume Allen's original action could not have pursued such an appeal on his behalf. And had Judge Gull refused the request, and had Allen been convicted, he would have had the ultimate appellate remedy, automatic reversal of any convictions based on his claim that the judge's disqualification of counsel amounted to structural error. Either appellate remedy on interlocutory appeal or after final judgment would have provided Allen all the relief to which he is entitled. Yeah, but like that time, like he's not taking into consideration the time and the families and the money. I mean,
to be like, dude, you got to go through your entire murder trial, get convicted, get to a different prison, start the really long process. I mean, it's there for you. You'll get there. You'll get there.
No doubt.
But I stand behind that technically at the end of the day, that was all procedural argument because he only cited the law for the purpose of saying it's not clear enough to fall into our little procedural world. That's the way I'm sticking to it. I'm sticking to it. How could she call the mooning? Is like through the mirror to the window, or
I think when she heard that I was with a group of guys and they knew that I was doing a live, that maybe they were going to act a fool, which they have been. I've been trying to ignore them. There's a lot of them. There's like 12, 13 of us here. All right. So C, finally, the court rationalizes its writ by claiming that we have repeatedly reviewed attorney DQ issues in original actions. In fact, our case law does not bear out a pattern of issuing writs in DQ disputes. Of the many cases the court cites, we issued a writ in only 2. In one of those, we disqualified a special prosecutor whose appointment violated a statute forbidding the appearance of impropriety. In the other, we DQ'd an attorney whom a state agency hired in violation of the statute requiring the attorney general to represent the agency. Unlike here, both cases involved the violation of a clear legal right or duty. But for the writ, counsel's continued representation would have exceeded statutory authority. The court today flouts our original action rules to award extraordinary mandamus relief in favor of Allen and against the trial judge. In doing so, we allow Allen to short circuit the appellate process and invite future deviations from our rules. In my view, these institutional costs far outweigh the benefits to Allen. For these reasons, I respectfully dissent from part 1. So that was it. And that was Gull's attorney's argument. It's like, hey, and the chief judge was a little snarky in her response back. She's like, well, I appreciate you're worried about our docket. We'll handle that, because that was one of his things. It's like you're carving out this exception where everybody whose lawyer gets bounced is going to be running up to them, and
he just answered Aspen's question. He was like, no, you're not coming back in here for something that doesn't fit in the parameters of a writ.
Yeah. So that's it. I don't know were you checking out the stream? Like where are we at? Like Kara was not thrilled with the opinion. Like she was disappointed. I think primarily obviously in the Gull situation. My thing is just moving forward. I just don't see how this thing is going to work. Like it's such a combative relationship, not just between Gull and Baldwin and Rosie, but everyone involved. You know what I mean? It's like every single one of them involved is like gotten like all up in each other's ass, and it's I don't know. I'm very worried about it. I'm very concerned.
He said they were flouting the rule, right? Was that what the judge said? So that I was going to answer the question about flouting.
Oh, wait, what did you ask?
What the judge, I think he said there.
The court today flouts our original action rules to award extraordinary mandamus relief in favor of Allen and against the trial judge. In doing so, we allow Allen to short circuit the appellate process, muddy our own jurisprudence in this important area, and invite future deviations from our rules.
So he's basically using flout there to be like waving the rule around, like you're holding it up, you're, to show off something is typically what flout would be, unless that wasn't a real question. So I don't know.
All right. Let's see. Wait. Dr. Von Kay, last night in criminality, they said Gunn has done this before to other defense attorneys in other case. I would like to see a case where SCOIN has approved a defendant's move. I had somebody just, who I'm not going to name because she wants to remain nameless, who just sent me something very interesting that I'm going to be reading over the weekend. And it might be worth talking about because
now you have us all in suspense.
Well, it has to do with a Gull in a different case. Regarding a motion to dismiss. It's interesting. I'm going to read through.
And then he'll be back to tell you all about it.
Right, because it may be showing a pattern of how Gull operates that is interesting. I fully intend on trying to get. I want to get Kara back on. She admitted to me that she cheated on us with another YouTube channel the other night. She's
a thing.
Like, wait, you cheated on us? She's like, oh, well, you guys. She's like, you guys are, I have to admit, you and Arlie are doing such a better job. I'm not going to name the other show.
You shouldn't have said that at all. I can't believe
you name the other show. What difference does it make?
Objection Strike that from the record.
Yeah, fair enough.
Wow. I mean,
Um,
literally, she's only been on one other wow. Okay.
I mean, she deserves to be on all the
Yeah,
shows
can
because
we
I love her so much.
rewind? Strike it.
No, I'm not
Stricken.
striking that. What does
Stricken.
she love us? What
No, not
like
that
she
part.
loves us? Which part am I striking? That the other show wasn't as good as we are? I'm
Wait,
not striking
th
any of it.
it was a
Denied.
joke
You're
anyway.
denied. So do you want to take care of the thank yous and the questions so I can bounce? I am.
Yeah, yeah, I'm not doing hugs. I mean, I can
What?
do some hollers, but
What was the temperature on?
they liked it. I'm
Family. Of
not
course they like it.
feigning
It's
the
sweet.
hugs.
Wow. See, she's a hard woman. She's a hard woman.
Like, I mean,
I'm the
everyone
softie.
saw how I
I'm the
responded to
softie
it.
in
Now
it.
I'm supposed to do it too. Hi. Okay, thank you.
Oh, can you even
Ooh,
do it? Let me
hi,
see. Can you do
hug.
aw, family hug? Aw. I
Aw,
think people
aw.
love it. I love to give family hugs. I'll only do it when Allie's not on. How about that? I'll
No,
give
you
family
can do it.
hugs.
I'm just not doing it.
I
You
mean,
can
you were
family
giving me the
hug the
business yesterday when I was family hugging people.
but people loved it. They loved it. It
Well,
kinda
I was trusting you. You're like, "Oh, people seem to be hating it. They hate the
yeah, but
family hug."
then they came back. Came back in strong with, liking the
All right.
hug. Everyone needs a virtual hug now
People
and
like the
then.
Armada. The Armada
I like the
is
Armada. I think
Armada's
that's
pretty cool. Somebody
Armades.
came up with a
What's because an Armada is everyone. So what
no,
is
somebody came up with a great one last night. Like, I love Armada, don't get me wrong. It blew my mind. It was so good. It had our name in it. I think it might have been Mandy, type it in the chat, Mandy. I think it was in our Discord, in our mod group from
somebody
Discord. Like,
I saw someone who put a couple together. It had like Motley Crue with double T's. The there was a bunch of good ones. I now blanking on it because my mind.
all right, let's see here. Is
I answered
Mandy
all like the
Mandy will put it in. It was great, and it had our name in it. It like had Mata, and they're like the same way that we use modified. You know what I mean?
yeah.
Um, so it was really good. Hopefully she can throw it in there. Let me see here. Hold on, I'm trying to handle something right quick. All right, so this is what I'm doing for y'all because I love you and because I love my boys, Dan and Steve. When I'm done here, now I don't know if you guys have been privy to this potential serial killer case, Brian Wilson, that's happening in Alaska. Dude is from South Africa. It's a crazy story. They end up like figuring this guy out when a sex worker that had obviously engaged her services had stolen either the entire camera or the drive. I don't know if it was a thumb drive or a jump drive or an SD card, but she pimped it out of his camera. Turns out that on that SD drive, he had filmed two women that he had unalived in the Marriott hotel
What?
and worked at. Yeah, that's how that whole case started. It's crazy. So my boys over at Publicly Buzzed are knee deep into that. And what I'm gonna do is I'm gonna portal y'all over there. I'm gonna redirect it now. So I hope that you guys will hang with them because those dudes they're the
I,
truth. They're the
I was just
absolute truth.
I was just looking over the comments again, and then I don't know what I answered when
And I'm
the
telling you right now, if Dan and Steve weren't going, I send y'all over to my girl.
damn you broke up. All right, we need a correction on the record. As I was just looking back through these comments and my 2 hours of sleep, when the judge says they flout the rule, it's like to completely ignore it and like say, like completely ignore it and just I don't know how I answered before. And now Bob is definitely gone. Plus, I'm getting a cold, or the lack of sleep is making it worse, one or the other. It sounded like he was trying to send you guys somewhere. I don't know if it was publicly buzzed or someplace else, but so I do wanna thank everybody. I know I went through most of the questions, but, uh, Snarky Sass Angel, thank you, $9 holler. I'm not good at this. This is like what Bob does, but, no, you rock, and thank you. But she says, "Thanks for your true heart." Ah, he's back, thank God.
My signal
I
sucks.
cannot do a holler. I'm just so glad you came back.
Oh, for the howlers?
Oh, Lord, it was
All
bad.
right, who'd you do?
I started to do Snarky Sass Angel, but she
Did you
barely
read
got a
what these
holler.
Oh,
She did, I told her
$10
she
holla. Whoop, whoop,
he's
whoop.
frozen. Oh, I hope he stays
Don't
like that
it's
for
and it's not
somebody take a screenshot. Wait, I'll do it too, actually. I'm gonna flout this, but not really, because that's the opposite. Um, all right. Thank you for keeping us so informed, y'all rock. You rock. Thank you very much for the now I definitely can't even do a $5 holler. $5 holla. All right, thank you, Laura, for the $2. And this is painful for all of you to watch. It's gotta be. Um, Always looking forward to hearing from us both. We do appreciate it and I absolutely appreciate you guys watching and especially you guys, contributing. Gotta go with Armada. I really do like Armada. I was waiting for Bob's answer because I think technically, like, it can refer to everybody, so I wonder how it works when it's, oh, look, somebody did that, and it wasn't me. Maybe Bob's controlling things. Oh, that was a question that Bob asked. Okay,
Oh, it's Speedy.
she put up the
Alright,
name
I'm
for you.
out. Like, my which
Enchiladas.
was it?
Enchiladas?
No, that wasn't it.
Oh,
That's like enchiladas. No,
yeah.
no, it was way better than that. That's cute.
Sorry,
That's cute for
sorry.
if I'm opening a Mexican restaurant. That's my
Yes.
Mexican restaurant name, enchiladas.
Well, you gotta
Matis, I
do
love the
something
Matis. That
special
was
for this person before you leave because she
oh, 20
donated a large amount last time.
holla.
Did we decide where
Holla.
DKK was, where we
I
thought it wa
love it. I
where
love it. All right, I'm like my connection.
Yeah, you're gone. Goodbye.
Love
All right.
I'm gonna
All right, so let me just Danish. I switched back over to the regular comment side. So that's, Danish. That's where she's from. Um, bye, babe. So, Emily, thank you. Oh, I just did that, I think. Oh, and gifting of memberships. Very, very nice of you, Shiraz. We appreciate it. Jen as well, 10 Defense Diary memberships. That's extremely thoughtful of you. And Heather's added as well. Thanks a lot, Heather. We really do appreciate it. I know I read some of you guys' comments before, but didn't thank you. So, Smiley Kylie, I so appreciate you guys constantly dumbing it down for us or screwing up words like flout, but don't worry about it for me. I mean, that is love the reading and the pausing to explain. Thank you both. Much love. And thank you for your generosity. And Megan, you know what? I actually didn't talk about this because it wasn't really a question as much as a comment. And hopefully everyone who, saw it, but it's definitely worth, noting about the conditions in Westville were all stated. At this point, is there a point they'd step into that? How so? Also, how is the state able to keep him from knowing why he was moved to Wabash? Okay, so I don't know if like this matters, but I saw a motion that got filed by the DOC as though, and I understand everyone wants to know, but why? But that it was the DOC decided to move him, and I don't know that will necessarily, ever know why. But that it didn't come like from the court or a lawyer, but maybe everybody already knows that. But thank you very much. It was very generous for your $20, and we really do appreciate it. Candace, 19 or $20. Do you think we talked about that, but thank you very much for the $20. That was very thoughtful. Jolene, very generous, $20. It's like I just want to read it, so I want to say $19.99. I'll get Bob to do the $19.99 holler. $19.99 holla. All right, it's really bad. Thank you, $10. That was very thoughtful. And I did read that comment earlier. So, Cryas or
That's
Kralles?
bougie owl, since you're so afraid to say it. Bougie.
Well, I know, I'm not feeling so great and I can't see. So the letters were running together. So I wasn't sure. I don't know what's going on, or it's the lack
I'm
of
seriously
sleep.
bouncing.
We
$10
all are.
holla, $20 holla, $20 holla, $20 holla, $5 holla, $25 holla, gifted membership, family hug. Aw, family hugs. Jen, always givers. Are you like, we have our always givers that always give you a
Oh, someone did that.
Stevie does it. Stevie's back behind
Stevie.
behind the
He's
curtain.
behind the curtain.
Ross, 20 like gifting 20 memberships to
Hey
lucky
guys,
folks.
before everybody bails, when they don't forget Defense
$5
Diaries.
holla. Raptor RN.
Diary.
Michelle, $5 holla. Thank you. Snarky Sass Angel, $10 holla. Thank you. Laura Crystal, $2 holla. Emily, $2. Emily likes the Armada. I really dig the Armada. Heather N gifted one delicious podcast membership.
I did it. I thanked everybody.
Aspen, did you answer Aspen's?
Yes, I answered it actually twice, because then I said the Supreme Court answered it too.
All right. So thank you, Megan Z, for your $20 holla. Candace for your $20 holla. Jolene for your 20. Bougie for your $10 holla. And then, of course, like, I want to butcher that. Krails. It's either Krails or Krayleys.
I did like it. I did it like it was a double,
Can I call you
L,
Mr. or Mrs.?
Y.
I can't tell. And then a woman in the picture, it could go either way. Ooh, a matter of fact. As a matter of fact.
As a matter
All
of
right.
fact.
I love y'all.
That's a good one.
I'm bouncing. It is a
all
good
right, me
one.
too. We're all leaving. We're all
all right, y'all. We love you. I'm going to be coming back. It probably won't be until Monday, unless, God forbid, something insane happens in this case tomorrow and I'm forced. Just when I thought I was out, they pulled me back in. Otherwise, probably Monday, since I was going to try to figure out how to get from wherever I am in Tennessee to Delphi. I'm so relieved I don't have to do that, because it was going to be a nightmare. So that was really, really nice.
Okay.
All right. That's it. We love you all. Thank you so much for your support. Thank you so much for being here. Make sure that you subscribe. I think we're over 13,000 K. So thank you. Big celebration for that. And make sure you're sharing, subscribing, liking, all that stuff. Because we want to get the show out. We think we're pretty decent. You guys let us know. But we love you guys.
If you like Bob, I'm not kidding, and I know I'm biased, but Defense Diaries season 1, the Gacy tapes, it is phenomenal. It is amazing. It is scripted. It is Bob, and it is interviews, and it's like a movie beyond movies in your ears.
And we uncovered the incredible true story.
I know, but I don't want to.
Gacy. Well, you don't have to tell them.
Right.
We uncovered new shit in that case that is going to blow your mind. And it's not about Gacy. It's about the victims. It's about the investigation, the arrest, and the trial. Like, we give so much love and respect to the victims and try to memorialize them. It's not a Gacy fanboy thing. Like, it's not. That's not what I was doing. There's enough of that shit out there.
It's not really about. Yeah, that really
Gacy.
aspect of it at all, right?
You hear the tape, but like I said, it's not a Gacy fanboy piece at all. So, all right, y'all, we love you because without you, I'd just be an old man with
Talking about a
beautiful
hell of a lot of
co-host
cases.
talking about.
A hell of a lot of cases.
You said it, baby. You said it. All right, talk to you next time, y'all. Thanks for being here. We love you.
Stop throwing me in.